Okay, good morning and welcome to Wednesday morning's online seminar. Today we are joined by Conor Ahern, consultant solicitor for civil law, and it is the latest in his QS series where he's going to be talking about concurrent delay. As always, Conor is happy to answer any questions you have, so pop those into either the Q&A box or the chat tool in the bottom toolbar of your screen. Alternatively, if there's something you don't want to ask in an open forum, you'll see Conor's email details later in the presentation, and please feel free to email him directly with any queries that you have. In the meantime, Conor, I will hand over to you and take it away, please.
Thank you, Julie. Good morning, everyone. You're all very welcome to latest topic in the QS series. This is a new topic for us. We're looking at concurrent delay today. Yeah, concurrent delay. Obviously a term that gets used a lot in industry, yet there are quite a lot of misconceptions around it. So we're going to look at that in greater detail now. So look, that's the intro. We get going. That's a bit on my background there. Obviously, I come from a QS background, hence why we use the QS series. Ideally, this information, helps QSs in industry, and QSs and other professionals who, who come across these topics on a very frequent basis. So ideally, it gives you an idea how to deal with these issues and obviously protect yourself to have a successful outcome. So that's really the theme that's the information that we want to digress with in these seminars. So the agenda today, we're going to look at what is concurrent delay. So just look at a good definition of what it is. We're going to look at the legal background. So we're going to look at some important case law in this topic and look at how the area has developed over time. We're going to look at concurrency clauses. Very frequently now we see amendments to the concurrency position within schedules of amendments that are typically used along with the standard forms. Often obviously the schedule of amendments can be even longer than the standard forms, but take from that what you will. Then we're going to quickly touch on how to deal with concurrent delay should you come across it, before finally concluding the seminar. And we hope to do that around 8:45, and we'll have some time for some Q&A then at the end. Okay, so what is concurrent delay? So concurrent delay can be defined as a period of project overrun which is caused by two or more effective causes of delay of approximately equal causative potency. Now, the important words there are obviously approximately equal causative potency. This is from the case of Adyard Abu Dhabi versus SD Marine Services back in 2011. Now, it's basically a good working example of what in fact concurrent delay is, because that point about equal causative potency basically means that you have a delay caused by two equal events, and obviously that takes into account the delays to the overall completion date. So two competing events, we'll come on to it even further, one obviously being an employer's risk event and the other being a contractor risk event. But remember that term, the equal causative potency. Where there is an employer delay and a contractor delay, causation becomes an issue, because the problem is that a contractor cannot prove that but for the employer delay the work would have been completed on time. He cannot prove that as a matter of fact, because it almost becomes hypothetical really that he's saying that but for the employer delay the work would have been completed on time. And conversely, the employer cannot prove either that but for the contractor's delay the work would not have been completed on time either. So you can see the issue. You can see where the contractor makes the case. He says, but for your delay, I would have completed the project in line with the contract completion date. And the employer also has the same argument, but they cannot prove it. And basically, what they're looking to show is that on the balance of probabilities, that position is correct. And the final point here is that concurrent delay is, it's regularly discussed, but in reality, true cases of concurrent delay are actually quite rare. It's quite unusual that you would have, two competing events, one being an employer's risk and the other being a contractor's risk, occurring at the exact same time, which both cause delay to the overall completion date. I mean, I'm sure you come across it regularly in industry, but it's very, very unusual. It's quite unusual that those set of circumstances actually stack up. And I imagine a lot of people in practice come across this quite often. And we'll come on to the points about dominant cause. I mean, of those two events, it's more than likely that one over the other is the actual cause of the delay to the completion date. And causation is really the big point. When we're looking to prove our concurrent delay. From a contractor point of view, obviously trying to establish that as an employer risk, and the same applies vice versa for the in the employer situation. Okay, so how did the courts approach concurrent delay? So to understand how concurrent delay should be addressed, we have to take into consideration the court's approach. Now, the courts of England and Wales, brackets let alone Scotland, have not been altogether clear on the subject. The position in Scotland is actually different to the position in England and Wales. There's a case called City Inn versus Shepherd in Scotland that we'll discuss later on, and we can see how it differs in its approach. For the best part of the last century, the courts examined whether an event was a dominant or proximate cause of delay, and we'll see which one of those tests applies today. So, how did the courts approach concurrent delay? So in Royal Brompton Hospital versus Hammond, it was said that necessary to be clear what one means by events operating concurrently. So you can still see the courts actually having to deal with what the meaning of concurrent means. He considered what is meant by events operating concurrently is that the works are proceeding in a regular fashion and on program when two things happen, either of which, had it happened on its own, would have caused delay, and one is a relevant event while the other is not. So you can see here that in Royal Brompton, that they're basically explaining what concurrent delay means. This is a Court of Appeal case as well, and they're obviously saying that the works are proceeding in a regular fashion and on program when two things happen, either of which, had it happened on its own, would have caused delay, and one is a relevant event while the other is not. Very important, obviously, that one is a relevant event, because if neither is a relevant event, obviously there won't be any concurrent delay. It will simply be a contractor's delay, and he will not be entitled to an extension of time. So the dominant cause approach has increasingly been viewed as artificial, and it's often seemed arbitrary to choose just one from among several competing causes, rendering the others immaterial. This is confirmed in Adyard Abu Dhabi versus SD Marine Services, and said it makes it clear that there is only concurrency of both events in fact cause delay to the progress of the works, and the delaying effect of the two events is felt at the same time. So again, you can see there's a bit more consistency coming into the definition of what in fact concurrent delay is. So the dominant cause test, after the dominant cause test has fallen from grace, what we're seeing is in Henry Boo Construction versus Malmaison Hotel, the Court of Appeal held that if there are two concurrent causes of delay, one of which is a relevant event and the other is not, the contractor is entitled to an extension of time for the period of delay caused by a relevant event, notwithstanding the concurrent effect of the other event. And this is largely the the definition that continues to this day. The dominant, there was talk of dominant cause, proximate cause tests, but basically Malmaison is basically the position now where it says if you have the two concurrent causes, one is a relevant event, the contractor is entitled to his extension of time for the period of that relevant event. Basically, yeah. So Malmaison. So 2 causes of delay. One at the risk of the employer. The contractor is entitled to the EOT for the period of the overlap, effectively. This does not, however, mean that the contractor can recover loss and expense as that it incurs during this period, unless the contract has been so amended. And that's just an important point to bear in mind when you are dealing with, I suppose, with delay and concurrent delay also, is that relevant events do not automatically become relevant matters also. So the relevant events obviously deal with time, the relevant matters deal with money. And if you have an event that occurs which delays the overall completion date, unless that is also included in your list of relevant matters, then you will not be entitled to your loss and expense. It's just a very important point, and one that often gets confused, because it's assumed that because you've been delayed that you're entitled to your costs, but that's not always the case. Just bear in mind that just because there is a relevant event, it does not automatically become a relevant matter. Now, if you look at the standard forms, there is a large crossover between relevant events and relevant matters, but you got to really look at what your contract actually says. Okay, so in the wake of Malmaison, some believe that a more flexible approach should be taken in respect of concurrent delay in circumstances where blame could be apportioned between the parties fairly and reasonably, taking into consideration the culpability and significance of each delay. At this point about apportionment, this is where the Scottish courts dealt with. That's the point that the Scottish courts dealt with in the case of City Inn versus Shepherd. And what they established was that they would look at the delay events and basically apportion risk between of each event to either the employer or the contractor. I don't go into it in too much detail here, because we're focusing on the position here in England and Wales, but that is an approach that has been taken in Scotland, but it's not followed. It's not followed here in England and Wales. The Malmaison approach is the one that still applies here, as will be confirmed in the case of Walter Lilly versus McCoy. This case from 2012, where they set out the principles in Malmaison and effectively approved the position that was put forward in Malmaison, when it said, I'm clearly of the view that where there is an extension of time clause such as that agreed upon in this case, and where delay is caused by 2 or more effective causes, one of which entitles the contractor to an extension of time as being a relevant event, the contractor is entitled to a full extension of time. The fact that the architect has to award a fair and reasonable extension does not imply that there should be some apportionment in the case of concurrent delays. The test is primarily a causation one. It therefore follows that, although of persuasive weight, the City Inn case is inapplicable within this jurisdiction. So that's basically Justice Aikenhead in Walter Lilly versus McCoy saying that here in the UK, or sorry, here in England and Wales, the position is that if there is a relevant event, the contractor is entitled to a full extension of time for the period of that relevant event. He basically rejects the approach in City and the, I suppose, the option to apportion risk between the parties. What he's saying is that there needs to be more certainty than that, and certainty in his mind comes from the fact that if a relevant event occurs and it delays the overall completion date, then the contractor is entitled to a full extension of time. So again, you can see the development of the case law in this area. There has been much debate about dominant cause, proximate cause, apportionment, various different concepts that the courts basically have grappled with over the last 100 years, even when it comes to concurrency. But that's all been dealt with, and as things stand at the moment is where you have delay, concurrent delay, one of the delays is an employer risk, which is listed as a relevant event or compensation event if you're dealing with NEC. Well, then the contractor will be entitled to his extension of time for the period of that relevant event. So I hope that brings some certainty in relation to how to deal with concurrency. If you come across it on any of your projects, and basically the conclusion in this section is that the Malmaison approach still applies. Malmaison, which again confirms the relevant event, entitles the contractor to a full extension of time for the period of that delay. Basically, that's what's been confirmed also in the case of Walter Lilly versus McCoy, which is from 2012. So yeah, so look, you can see what Justice Aikenhead was doing in Walter Lilly. He's trying to make it certain. He's just trying to sway through the different points that have been made on concurrent delay over the years, and basically define that, bring clarity to the situation, which is helpful in industry and for practitioners and industry professionals alike. So that concludes this section. We're now going to move on to the prevention principle and the doctrine of prevention. It's a very important concept when we're actually looking at concurrent delay. And so what is it? So the prevention principle provides that a party may not require the other party to comply with a contractual obligation in circumstances where the party has itself prevented compliance. And now what we mean by that is, if the employer prevented the contractor from carrying out the works according to the original completion date, the employer cannot then insist that the contractor meets the original date for completion and then seek to claim liquidated damages on account of the contractor's late completion. So that's the prevention principle. It's where basically a party cannot benefit from its own breach. That's the position, and you can see that it makes a lot of sense, because if an employer delays the contractor, be it deliberate or otherwise, then it cannot be right that the employer basically can instruct he can instruct the contractor to accelerate as long as they pre-agree costs, but he can't instruct him to complete the original date, because it's no longer possible due to the employer's delay, and also then that he should be prevented from recovering damages, because that's basically benefiting. That's the employer benefiting from the breach that he has caused to the contractor. So that's the prevention principle. You could see, why it's important in relation to delay, but especially concurrent delay. And basically looking to avoid a situation where the party in breach can actually benefit from that breach. So we're going to move on to some case law that looks at this principle. And the first case is in Multiplex Construction versus Honeywell Control Systems. Justice Jackson set out three propositions concerning the prevention principle. The first proposition was that actions by the employer, which are perfectly legitimate under a construction contract, may still be characterized as prevention, and if those actions cause delay beyond the contractual completion date. Now, items that Justice Jackson is in his mind there is, variations is a good example, because variations obviously add to the scope of a project, and employers, should be entitled to use variation provisions under a contract where possible. Things change, and that's exactly what the variation clauses are there to cater for. But what he's saying is that it can be characterized as prevention, and if the actions cause delay beyond the actual completion date or the contractual completion date. The second point is that acts of prevention by an employer do not set time at large if the contract provides for extension of time in respect of those events. Now, This was a very common type argument in the past, where if the employer delayed the contractor and the event that was not catered for in the I suppose in the extension of time provisions, or it wasn't listed as a ground as a relevant event, then basically the position was that the contract didn't cater for that extension of time, and time became at large in those circumstances. But we don't see time at large arguments quite as frequently anymore, because the standard forms of contract have been updated to such a large extent that pretty much, most events that occur on construction sites at present are catered for under the detailed relevant events or compensation event grounds that are listed in standard forms. And it's for this very reason, because employers want to avoid situations where contractors put forward arguments that time is now effectively at large, because time at large basically means that the original contract completion date falls away, and basically that the contractor has to complete within a reasonable time, and therefore is not susceptible to deduction of damages also. But this is in 2007. Standard forms were being updated at that time, and have continued to be updated. So as I said, it's very, very rare now that that events would happen on site which are not catered for under the extension of time provisions. The final ground here is that insofar as the extension of time clause is ambiguous, it should be construed in favor of the contractor. So interesting proposition put forward by Justice Jackson, and sets us up quite nicely for what happens in the following case of North Midland versus Side and Holmes, which ended up in the Court of Appeal. Now, this is an important case that discussed the prevention principle at length, and warned parties on clauses to consider when agreeing their respective contracts. Such amendments reflect employers seeking to oust the standard position and deny the contractor an extension of time in the event of concurrency. So, like what we were discussing earlier, is that the current position in Malmaison, which was approved in Walter Lilly, what they're saying is that if there is a delay event and it's listed as a relevant event, then the contractor is entitled to a full extension of time for that duration. Now, what we're seeing here is that in North Midland versus Side and Holmes, there was you can see employers basically trying to change that position, and what we call ousting the standard position on concurrency. And it's become very popular, and it's basically a warning to, when you are agreeing the terms of your respective contracts, that this is really a ground that you need to look out for, especially from contractors' point of view, or subcontractors' point of view also. Okay, so in North Midland, so the parties they amended clause 2.25.1.3b in relation to extensions of time in the JCT design and build contract, basically to read that any delay caused by a relevant event which is concurrent with another delay for which the contractor is responsible shall not be taken into account. Now, it shall not be taken into account when calculating the extension of time which the contractor may be entitled to. So what they're saying is that they're basically reversing the standard position here, and it's quite a nicely worded clause, which can actually has more important consequences than you would pick up from it at first glance. And we call some of these clauses they're like a wolf wrapped in sheep's clothing, because they can look quite innocent on the face of it. But it can actually have quite important consequences for a contractor, especially when he's dealing with concurrency, when he's after applying for an extension of time. when on site. So that was the wording that was included in that particular contract. And basically North Midlands, they made two arguments when they proceeded to the TCC. Now, their primary argument was that clause 2 that the amendment offended the prevention principle as described by Justice Jackson and Multiplex, meaning that any interpretation of clause 225(1)(3)(b) that offended the prevention principle was not permitted. So that was the primary argument, that basically the clause offended the prevention principle, and as a result should not apply. The alternative argument was, regardless of the correct interpretation of the amendment, the prevention principle still operated in relation to the contractual liquidated damages provision, so that the contractor's liability to pay liquidated damages fell away. So you can see basically North Midlands, they're really trying to rely on the prevention principle as a means to basically avoid the agreed amendment. And the amendment was clearly agreed by them in the schedule of amendments, but now they're trying to rely on the prevention principle as an argument to say basically that where the employer has caused delay to us, we should be entitled to an extension of time, and obviously that will keep the liquidated damages at bay. So there you can see the primary and secondary arguments which were dealt with by Justice Fraser and the TCC. And what happened there was that Justice Fraser refused to grant any declarations of finding that the contract wording, and he found that basically the contract wording was crystal clear, so no point of interpretation arose. In addition, the court found no support in Multiplex for the contractor's proposition that this type of clause was not permitted. So what he's saying is that the wording is not, basically, it's crystal clear, and that is dealing with the third proposition by Jackson, which is saying that if the clause wording is ambiguous, it should be construed in favor of the contractor. Basically, Justice Fraser here is saying that we don't need to, that doesn't apply because the wording, the clause wording is crystal clear here. So there is no point on interpretation. And the second point, which is a very important point, is that he's saying in cases of concurrent delay, effectively, what he's saying is that the prevention principle is not triggered, and that's especially where the wording of the contract, he's saying that is not triggered where the wording of the contract suggests otherwise, and it has been clearly agreed between the parties. So that's what he's saying in relation to the concurrent delay clause, is that if you've clearly agreed a clause and you've clearly understood what it means, because the wording is crystal clear, then you cannot rely on the prevention principle as an argument afterwards, especially in relation to the position on concurrency. So the conclusion following North Midland, is basically that parties are free to allocate the risk of concurrent delay within their respective contract, and it's actually led to most schedules amendments now actually deal with the allocation of risk on concurrency, following the case of North Midland. One of the interesting points is, the judgment in North Midland that provides the form of words that parties can use, and we regularly see that basically those words that were included in that clause in North Midland have basically been taken and used in the standard form, which makes sense because it's been judicially upheld. There's no cause for there can be no confusion on the interpretation because that's already been dealt with. So it's quite sensible that we now have a form of words that deal with a correct amendment to the standard position on concurrency. And finally, what the TCC was saying is that parties, should not rely on the prevention principle when dealing with concurrent delay. Basically, what you're saying is that express terms agreed in the contracts, will take precedence over the prevention principle, and parties looking to rely on it will be unsuccessful. So that was the finding in the TCC, and this was subsequently upheld in the Court of Appeal also. So it's just it's an important point to bear in mind. I mean, we come from a position where Malmaison is a position where it's largely in favor of contractors, and you can see why employers would seek to amend that. And what North Midland does is basically say that if the contract, if you agree to amend, standard forms of contract, you can adequately basically overturn the standard position on concurrency, and parties should not rely on the prevention principle as a means to defend the reversal of the concurrent position. So basically, yeah, it's a warning. When you are agreeing the relevant events and your extension of time provisions, is that bear in mind if the position on concurrency has been amended, then basically this is what it means, and the contractor will not be entitled to his extension of time for the period of any concurrent delay where one of the delays has been caused by an employer risk event. Okay. Right. So on to the final section now. We're gonna quickly look at how do you prove your concurrent delay, or how do you deal with it? So some interesting points have been taken from the Society Construction Law, the Delay and Disruption Protocol, the second edition, which actually came out in 2017. So basically, I think I'm just having a quick look here in front of me. Section 10, I believe. Yeah, Section 10 deals with concurrent delay. So these points are effectively taken from Section 10. So what the SEL protocol is saying, that concurrency only arises where the completion date is delayed, and that is 100% correct, because if the overall completion date hasn't been delayed, then basically then there's we can look for an extension of time, but the extension of time provisions really kick in when the overall completion date has been delayed, because that's when the problems arise, is that you're going to be on site for a longer duration. And also, if the contractor is late, he's going to be liable for LADs. So, valid point there. What they're saying is that parties should adopt a common sense approach. That's quite, that can be interpreted in many different ways. But what they're saying is that to really, look at the merits of each delay event, and to see what has really caused the delay. Complete a proper analysis basically at the time, in order to adequately deal with concurrent delay. It is complicated, and the best chance the best chance a contractor has of dealing with it and having a successful outcome is obviously at the time, rather than trying to deal with it retrospectively, which can become quite difficult, but not impossible, but it is more difficult. The contractor should submit application in line with the contract. That goes without saying. Adhere to the notice provisions provided under the contract. What they're also saying is that employers should be careful that if they instruct a variation and the contractor recovers their culpable delay, this is in a position where the project is already in delay, the variation will become an effective cause and grounds for an extension of time. So what they're saying is basically it's a warning to employers that if the project is in delay, and basically due to the contractor's own delays, if you do instruct a variation that has that effectively causes a delay at the end, after the contractor may have accelerated or increased resources to mitigate their delay, then that can become grounds for an extension of time also. So it's just it's a valid point that I've included, because it does apply, and employers should be mindful of that. When they are looking to instruct variations, particularly towards the latter end of any contract. So how do you prove concurrent delay? How you prove concurrent delay is very similar to how we prove any delay, and some very useful cases on this area. Ascon Contractors versus Alfred McAlpine Limited, where in that case the judge concluded that wholly theoretical calculations will be unlikely to succeed. And he's talking about all delays when he mentions that, and it basically it's a warning to say that don't provide theoretical calculations. Look at the facts and the circumstances as much as possible, if you want to justify your delays. And the same obviously applies to concurrent delay. In Skanska Construction versus Eger Limited, it was observed that the sophisticated impact analysis of an expert was only as good as the data put in. So that's basically, reminding parties that the need for good record is very important. When you're dealing with delays. So timely notices, correspondence on delays at the time, updated dropline programs, very useful. Updated progress reports as well. All that information, site diary is really good, just to be able to point to the information that shows that any delay analysis is correct, and it relies on substantial and detailed data, which is the bedrock of any good application for an extension of time and to be successful. Okay, in the recent case of Northern Ireland Housing Executive versus Healthy Buildings Ireland, the court confirmed that a retrospective analysis was generally preferred due to the benefit of hindsight and the certainty afforded. What is all the more surprising in this case is that the form of contract was NEC, which expressly requires prospective analysis. So I mean, it's quite interesting from that point of view, because NEC obviously tries to predict, it looks to be proactive, certainly more proactive than the JCT forms, where they're constantly looking for updated programs in order to anticipate the extent of the overall delay. So this case was quite interesting insofar as the court was basically saying that retrospective analysis can it can be preferred once the project is complete. But so it's interesting position put forward. I mean, all those at NEC, I would have thought that it's better to be proactive. I mean, it's better to be proactive on both NEC and JCT as much as possible. But what the court here is saying also that that the retrospective analysis, because you basically have visibility over all events, it can actually be a more accurate form of analysis, which does make sense, because you have full visibility of all events that have been carried out, but also all events that have delayed the critical path, and as a result delayed the overall completion date. So the judge in this case, concluded, he's basically said, interesting, I guess, statement is that why should I shut my eyes and grope in the dark when the material is available to show what work they actually did and how much it cost them? It therefore follows that the courts are likely to prefer a retrospective analysis on the basis that it uses actual data and is therefore neither theoretical nor arbitrary. So, again, I guess, a good point in relation to the information that's being used to produce any delay analysis or any retrospective critical path program analysis, is that it's only as good as the information that has been used, and it remove any kind of theoretical points that have been made within it, and basically look at the facts, the facts and the circumstances that surround any of the delay events, and that will give you the best chance of success when you're dealing with delay analysis, which obviously takes into account any concurrent delays also. So as always, choosing the correct method and how to deal with concurrent delay correctly. It depends on it will be driven by the the quality and accuracy of the information that is available. So that's a good warning. We always say everyone says, records are so important, and generally we see that, contractors, in cases, contractors, and where under a main contract, contractors tend to have, better records than their employers, simply because they've been, they have the experience, they've seen more than likely have learned a valuable lesson as to the value of accurate record keeping, and they generally have the systems in place to record events more often than not, more accurately than what employers would have. So again, just final, I suppose, word of warning: when you are looking to deal with concurrent delay, look at the records, look at the correspondence, look at all of the surrounding information. Big one is obviously in relation to time, issuing of design information in a timely manner. That's obviously very important. And then probably the largest ground that we see as a reason for for project delays. So yeah, that's kind of the final word of warning. That's what the courts are saying. Don't bring theoretical analysis to us. Look at the facts and circumstances, and put forward your best case based on that information. Right. So we're going to conclude there, everyone. So that basically we've looked at concurrent delay, the development of the case law, where the current position that we have here in England and Wales. Obviously, the Malmaison approach is that if you have concurrent delay, the contractor is entitled to a full extension of time due to the employer's risk or the relevant events under the standard form of contract. Obviously, we moved on then to look at the prevention principle, and the position in North Midland is where we're seeing employers basically amending that standard position on concurrency. So it's a word of warning to any, when you're agreeing your contracts, to look out for the concurrency clause, and because as was the case in North Midland, it did have it significantly reduced the the contractor's entitlement to an extension of time. And finally, we just had a quick look of what principles to bear in mind when you're dealing with your concurrent delay. It's no different really to dealing with any form of delay that you incur on your construction project. The advice is keep good records, have plenty of information that you can rely on to substantiate your position. Don't rely on theoretical positions, because the court won't buy those. And yeah, look, again, a lot of our seminars end up in the importance of records, and today is no different. So just a final point there. Look, that's about it. So we're gonna wrap it up there. I'll hand you back to Julie. I see there's some questions, and we'll now take those. Okay.
Thanks, Conor. That's great. And there are indeed some questions. Someone's asking, on an NEC3 subcontract, if the contractor displays an access date on the subcontractor's accepted program, which causes a critical delay and would be a compensation event, however, the subcontractor is experiencing activity delay in other areas which are not critical, but they could become critical due to the staking of program activities for others. Well, could there be an argument for concurrent delay, and how would this be dealt with?
Yeah, very good, very detailed question here, which I love, Julie. I'm just reading it here on my screen, actually. So the contractor has delayed an access date, and which is a critical delay, and would be a compensation event. However, the subcontractor is experiencing delay. Yeah, I mean, basically you have two delays. One is critical, and importantly, the contractor's delay is critical. And the other delays, obviously, the subcontractor may have issues in other parts of the site, but these are not critical. Obviously, any non-critical event which is on a construction program can become critical if it's delayed for long enough. here, though, I think, there could be an argument for concurrent delay. You obviously have two delay events, but I mean, under the standard position in Malmaison, and obviously I don't know what if there has been amendments made to the subcontract, but here where you have a critical delay caused by a compensation event for which the employer is which the contractor is responsible for, then I think the subcontractor is likely to be entitled to an extension of time for the period of that compensation event. How would this be dealt with? Again, you've got to look. A program analysis needs to be looked at. I mean, really, unless they can come up with an alternative means of presenting the delay, because whilst it is a delay, what a program analysis does is actually proves a calculation to show how much delay has actually been incurred, how much critical delay has actually been incurred. Because what should happen after this in NEC is that the overall completion date gets extended to reflect the extent of the critical delay. And I mean, on the face of it, looking at it, delaying and delayed access to any area of the site, is likely to be critical. So if the access date is delayed by 10 days, for example, it's likely to follow that that the overall completion date will be delayed by 10 days. It looks like on the face of it, it is a compensation event. It looks like the subcontractor will be entitled to an extension of time. And it's got to be dealt with. It's really in some form of delay analysis would be the best way to do it, unless the parties can come up with an alternative solution, which may be possible here, given that it is delayed to an access to an area of the site. Okay.
And another question here. Someone's saying they often hear that concurrent delay doesn't exist under NEC, as each event is assessed independently as it occurs. What is your view?
Yeah, I mean, the concurrent delay, I would say that it does exist. I mean, it exists on concurrent delay occurs on sites, under any form of contract, really. And that's basically been borne out in the case law also, is that where you have two competing events which delay the completion date, that is in effect concurrent delay. I don't see anything expressed in NEC contracts that changes that view, or that says that concurrent delay cannot occur. I think the point with NEC is that they're looking ahead at the effect of delays to the overall completion date, and I think with that is that you're in better place to see whether the event is actually whether genuine concurrency is occurring. Like that earlier example, you had two delay events, but it looked like the late access was the critical delay. Here, because you are looking at each event independently, there's going to be some overlap of there's more than likely going to be some overlap of a employer delay, and where there's also ongoing contractor delay. So I don't think, this is under the standard NEC. I mean, obviously, unless amendments apply to say that, again, something similar like North Midlands, that that they basically amend the position on concurrency. I mean, I don't see that a concurrent delay cannot occur under NEC. Yeah, absolutely, it can occur, but it's just, and how it gets quantified is basically, following the approach in Malmaison, and the standard approach again is that for the extent of the employer delay, even where you have an ongoing contractor delay, you will have concurrency, and on the standard position in concurrency is that the contractor will be entitled to his extension of time for the period of employer delay. So So yeah, I mean, I don't see any reason why concurrency doesn't exist under NEC. I mean, obviously, as I say, unless it's been expressly excluded or amended between the parties, then absolutely concurrent delays can occur under the NEC contract.
Okay. We have another question here. How do you prevent the employer from making use of the no-cost extensions, such as excessively inclement weather, when the real cause of the delay is late information?
Yeah, good question. Because obviously, where an employer is seeking, he's basically, the employer is admitting that there has been a delay, but his position is that the ground is due to it's because of inclement weather rather than late information. Main reason being is that I'd imagine that employer will be well aware that adverse weather is not a relevant matter, which will entitle the contractor to loss and expense, and hence why an employer would want to steer the conversation in that direction. Obviously, I'm thinking of a standard JCT here where there has been late information. That's basically what that would fall under the impediment prevention or default clause. That's included both as a relevant event but also as a relevant matter. So if the contractor can successfully argue that the delay is due to late information, he will be entitled to his relevant event, so his time, but also his relevant matter, which means loss and expense and additional money. That comes down to again, there's going to be some extent of a delay analysis required just to show the impact of both. But I mean, where you got to look at what is the real cause. So you would have to draw out the dates. I mean, you'd have to go back to look at the dates when the employer should have issued information, the actual date when they did issue information. I mean, I can't imagine it'd be very unusual that you would have adverse weather that would basically would cover the extent of that delay. In relation to time here, you will have no problem getting your overall extension of time, though, where we're now straying into the area of loss and expense, and recovering all of the money, I guess, that flows with that delay. I mean, that's a bit more difficult, but it should be. I think a starting position is to show, if you produce a program analysis to show the position of when you should have got the information and when you actually did get it. I think you'll start to build a really strong case to show that that the contractor's position is correct, and that the employer is basically almost trying to create an alternative set of facts in order to keep his liability for loss and expense as low as possible. Okay. So I think that's where you'd start, and you just build up your case from there. Okay.
Okay. Great. Thank you very much for that, Conor, and thank you to everyone for attending this morning. We are back again this evening with Richard Silver in his Construction Essentials series, where we'll be looking at payments, specifically smash and grab. So if you would like to book a place for that, please drop me an email to seminars@silverllp.com. As always, if there's anything you've seen that you'd like to ask Conor but didn't want to ask it in an open forum, it's Conor Ahern at silverllp.com, and he's happy to take any questions that you care to send him. Other than that, we will hope to see you all again soon. Thank you all for attending. Thank you very much, Conor. Thank you for your time.
Thank you, Julie. Thanks, everyone. Have a good day, okay?
Have a great day, everyone.
Cheers. Bye now.